Clowes-Fellows, Senior Associate in the Employment Team at Mills & Reeve. Welcome to this episode of People Matter. Today I'm going to explore the spotlight that continues to be on the use of non-disclosure agreements, more commonly referred to as NDAs, proposed changes around the use of these, and best practice. So firstly, what is an NDA and how is it used in an employment context? NDAs were traditionally used in commercial transactions to protect trade secrets and commercially sensitive information. However, in an employment context, employers will rarely require employees to enter into standalone NDAs. In employment, we do have contracts of employment that contain confidentiality clauses, and those will usually seek to prevent the unauthorised disclosure by the employee of confidential information relating to the employer during employment and following termination of employment. We also see in settlement agreements that are used to either settle disputes or terminate employment, that those also contain confidentiality clauses. And these can be a simple restatement of the confidentiality clauses that were already in the employment contract, or it can impose new confidentiality obligations. Settlement agreements will often contain clauses preventing the parties from disclosing information about the nature of the matter to which the settlement agreement relates and the existence and terms of the settlement agreement itself to try and protect both the employer and employee. In addition to confidentiality restrictions, where the employment relationship has not ended on good terms, it's also common to include a restriction on the employee making derogatory comments about the employer. So moving on then to why has there been a focus on NDAs? What has this focus been and what's in the pipeline in relation to potential changes? Firstly, this came about from, in part, by the Weinstein scandal. And following that, the SRA issued a warning notice because that scandal brought the use of confidentiality clauses into much sharper focus. The #MeToo campaign highlighted situations in which NDAs and confidentiality clauses had been used inappropriately. And this is an issue that continues to dominate the news, with stories of Weinstein's retrial and also the news around CBI's reported history of using around 10 NDAs in 2023 to prevent staff from discussing their experiences of harassment, abuse and bullying. Developments in the use of NDAs include a Law Society practice note, a thematic review by the SRA, and a call for evidence from the Legal Services Board. So looking at these in a bit more detail, the Legal Services Board published a report on the use of NDAs in February 2024. And this report focused on how regulation and legislative frameworks can best address the unethical conduct of legal professionals, including in the context of NDAs. And it's thought that that work on potential additional regulation and legislation will take place over the 2024-2025 business year. There was also the Treasury Committee report on sexism in the city, and that report was published on the 5th of March, and it commented that it is shocking to hear how prevalent sexual harassment and bullying up to and including serious sexual assault and rape still are in financial services, and how poorly firms handle allegations of such behaviours. We were particularly concerned to hear of the widespread misuse of non-disclosure agreements, which have the effect of silencing the victim of harassment and forcing them out of an organisation, while protecting perpetrators and leaving them free to continue their careers and go on to abuse others. Responsibility for tackling these issues and drive much needed cultural change has to sit with the senior leadership and boards of firms. So as well as general recommendations on diversity and inclusion, that report also gave recommendations that the FCA collect data on the use of NDAs by regulated firms in cases of non-financial misconduct. So there remains an ongoing focus on this, and there are a few things to be aware of in terms of things coming up in the pipeline. So for example, on the 24th of May of this year, the Victims and Prisoners Act 2024 received royal assent as part of Wash Up before Parliament was dissolved in advance of the upcoming general election. And Section 17 of that Act makes void a provision in an agreement that purports to preclude a disclosure of information by a victim or a person who reasonably believes that they are a victim to certain individuals. So noting there that the definition of victim is set out in the Act itself, and then in relation to the individuals whom victims can disclose information to, those include any person with law enforcement functions, lawyers, regulated professions, or regulators themselves, for the purposes of seeking legal advice or support or cooperating with regulators in relation to conduct. It does set out that a provision in an agreement is not void by virtue of Section 17, so far as it purports to preclude a disclosure made for the primary purpose of releasing information to the public domain. A commencement order will be required to bring these provisions into effect, and it's possible that these measures will be brought into effect even if there is a change in government following the general election. There's also the Higher Education Freedom of Speech Act 2023, which the provisions under which are expected to take effect on the 1st of August of this year. And Section 1 of the Act inserts a new section which will ban NDAs in certain circumstances to secure freedom of speech at higher education institutions. These provisions are part of a wider picture restricting the use of NDAs in the higher education sector, and there are also further plans to restrict NDAs in relation to complaints of harassment, sexual misconduct involving students. However, again, we don't have definitive date for those measures yet. There is also the new duty on employers to prevent sexual harassment. So from the 26th of October 2024, there will be a new proactive duty on employers to show that it took all reasonable steps to prevent its employees from being subjected to sexual harassment. So finally, just a more practical look at what are the key do's and don'ts for employers and HR professionals when it comes to NDAs in the current climate. Firstly, just a short reminder that there have been key provisions around for some time, and those include the fact that an NDA cannot be used to prevent or seek to impede or deter a person from cooperating with a criminal investigation or prosecution, reporting an offence to a law enforcement agency, reporting misconduct or a serious breach of the regulatory requirements to the SRA, or making an equivalent report to any other body responsible for supervising or regulating the matters in question, and making a protected disclosure. In addition to those, you will also need to consider implementing the following: a thought process of how far does a confidentiality clause and terms of settlement need to go? So what are you actually seeking to keep confidential, and for what purpose? We would strongly advise against just including any confidentiality clause that you have in the past and taking a real step back to consider those key points. Do you need to keep the terms of negotiation of agreement as well as the circumstances surrounding termination confidential, and why? Consider any necessary carve-outs to those. Consider mutual obligations of confidentiality and non-derogatory remark clauses on both the employer and the employee. Use plain English and ensure the terms are clear and relevant to the issues and claims likely to arise. If you're using a settlement agreement, be aware of the legal requirements, including the need for the employee to obtain independent advice and give the individual time and opportunity to obtain that advice and support. Ensure the person is allowed to keep or receive a copy of the NDA. Ensure that only a director or appropriate senior manager signs off on the use of a confidentiality agreement. It should be somebody who was not involved in any discrimination or hearing any grievance related to it. And a reminder that managers should be escalating any concerns about workplace culture, systemic discrimination, or repeated or highly serious acts of discrimination by one individual. As I said, those are a few key points to bear in mind, but this is very much still a key focus and an area which will continue to change. So do keep up to date with changing practice and guidance in relation to the use of NDAs.